Ripple's chief executive officer, Brett Gallagher, has taken a firm stance against the Securities and Exchange Commission's SEC demand for a fine of $2 billion. Gallagher demonstrates that the warnings issued by the SEC are not warranted by his refusal to follow through with the settlement. As a result of Ripple's allegations that the government has exceeded its authority, the cryptocurrency world is getting set for a war of epic proportions. As the situation unfolds, make sure to keep an eye on it. Please remember to follow, like, and share this post. Now let's get started. In the first place, we are going to make a hasty strategy to establish a new digital currency platform by the central bank over the next 12 to 24 months. At the moment, central banks are testing XRP on the private XRP ledger, and the new Swift platform is able to connect to it by means of an application programming interface API. It is also possible that the court may issue a final ruling about the case, which would put a stop to one of the most significant lawsuits that the SEC has ever filed in the Bitcoin industry. As a result, XRP might be utilized by corporations, central banks, and exchange-traded funds (ETFs). The CEO of Ripple provides his response to the unexpected demand for $2 billion made by the SEC. It comes as quite a surprise that the United States Securities and Exchange Commission has proposed a fine of $2 billion against Ripple. In light of this disturbing demand, Brett Gallagher, the chief executive officer of Ripple, has taken a firm stance against the request made by the agency. He is determined to demonstrate the true nature of the Securities and Exchange Commission. According to the chief executive officer of Ripple, the requests made by the SEC are incorrect. As of late, Stuart Alderati, the chief law officer of Ripple, made the following statement in a post on X, which was once known as Twitter, that a judge has been requested by the United States Securities and Exchange Commission to impose a fine and punishment of $2 billion on Ripple. In addition, the chief operating officer of Ripple stated that the Securities and Exchange Commission is intent on punishing and intimidating Ripple rather than adhering to the law. In response to the $2 billion fine that the Securities and Exchange Commission SEC was given, Gallagher noted that the agency has consistently violated the law in a variety of enforcement cases. It was said by him that the judges had also taken note of the actions taken by the SEC. In the past, they had issued a warning to the agency stating that it was abusing the power that Congress had granted it in a significant manner. In addition, the chief executive officer of Ripple expressed his disapproval of the SEC's demand for a penalty, stating that it was irrational and lacked any basis in reality. This was especially in light of the fact that there were no allegations of fraud or recklessness in the case. In light of this, Gallagher has pledged to hold the Securities and Exchange Commission (SEC) accountable for its actions and has made it quite apparent that Ripple will mount a robust response to the steps taken by the SEC. It is important to note that Alderati stated that the company's attorneys will react to the requests made by the SEC in a file that will take place the following month. The chief operating officer of Ripple stated in his opinion post regarding the Securities and Exchange Commission (SEC) that the government makes statements that amount. The steps made by the SEC are in the best interest of those who own Royal XRP. The Securities and Exchange Commission (SEC) of the United States filed a lawsuit against Ripple, claiming that the payment business violated securities laws by selling XRP in stocks that were not registered. It is being offered for investment in the United States. A statement was made by the agency stating that the company and its officials had not done enough to protect investors by providing them with sufficient information regarding XRP. On the other hand, members of the Ripple community have stated that the actions taken by the SEC against Ripple have not adequately protected investors, but have rather made things more difficult and resulted in financial losses for holders of XRP. According to a well-known XRP supporter who goes by the name XRP Crypto Wolf, the Securities and Exchange Commission (SEC), but not Ripple, ought to be the one to hand out billions of dollars to XRP users. It is absurd that the Securities and Exchange Commission (SEC) wants to prosecute and fine individuals for more than $2 billion, yet they are the ones that cost XRP customers the most money. The SEC is owed tens of billions of dollars by individuals who own XRP, according to his statement. The member of the XRP community stated that when the SEC withdrew its lawsuit against Ripple, the market capitalization of the coin plummeted by approximately $15 billion. This was due to the significant impact that the case had on the value of XRP. In addition to that, it was removed off the major exchanges. Those who own XRP suffered a significant loss of financial capital. In the case of Ripple vs. SEC, the attorney who supports XRP provides an analysis of the SEC's assertion that it is entitled to $480 million. The Securities and Exchange Commission's SEC demand that Ripple pay them a massive sum of $2 billion is a significant case that is causing the cryptocurrency market to shake. Defending itself, Ripple asserts that the allegations are an attempt to intimidate individuals into letting go of their arrogance. Is this exactly the kind of significant shift that crypto laws require? Ripple Labs was dealt a significant blow by the Securities and Exchange Commission (SEC) in the most recent court action between Ripple and the SEC. The SEC stated that the cryptocurrency payment firm was unfair to institutional investors. Investors who did not receive any of the advantages in question were harmed by Ripple's selective markdown on its XRP token. According to the Securities and Exchange Commission (SEC), an important turning point in the court's battle was when Ripple filed its $480 million claim. People ought to exercise caution, according to a lawyer who is in favor of XRP. Bill Morgan, a well-known supporter of Ripple and XRP, was quoted as saying that users should exercise caution in reaction to the claim made by the SEC. There are some valid points that Morgan brought up when he suggested that the SEC's position could possibly lose ground. He stated that it would be difficult for Ripple to prevail in the next court battles, and he stated that although if the SEC's claim of $480 million in damages appears to be quite substantial, the information that supports it needs to be covered. He also stated that the case needed to be examined in greater detail, and he questioned the belief of the SEC, as well as the magnitude of the damage that Ripple's acts were supposed to have caused. He emphasized that it is not simply the case itself that is important. According to Morgan, and we must not overlook the potential impact that this may have on Ripple's reputation among major investors. Spreading the word to the general public about the exclusive discounts that are only available to Ripple users will be detrimental to the company's reputation. There is a possibility that the general public does not feel that the corporation will adhere to the regulations or rules. Morgan was concerned that if he told others about this, it would be detrimental to Ripple's reputation and would make the company's legal and commercial issues even more severe. Ripple and the Securities and Exchange Commission (SEC) were invited to meet with Fred Rispoli, a well-known attorney who specializes in XRP, in order to discuss the present issue. The meeting was requested in order to facilitate the discussion. According to what Rispoli has stated, it is possible that the difficulties that the Securities and Exchange Commission (SEC) had when attempting to determine the amount of damages received by investors will have an effect on the result that the court comes to. Moreover, he discussed the impact that significant discounts on XRP sales are anticipated to have on sales, as well as the implications that this has for institutional clients like GSR. He also emphasized the implications that this has for the market. A further point that he brought up was the consequences that this had for the market. Furthermore, he brought up the fact that it is believed that these price reductions have an effect on sales, which is something that he has mentioned. Judge Torres was presented with the case that had been crafted by the Securities and Exchange Commission (SEC). Furthermore, at the same time, the Securities and Exchange Commission (SEC) presented a petition before Judge Lisa Torres, urging that Ripple be subjected to severe fines. In addition to this, the authorities asked for compensation in the amount of more than $2 billion, as well as interest on claims that were initially submitted prior to the verdict, and civil fines. Furthermore, they contended that Ripple had violated a number of regulations that were related with securities. This was in addition to the previous point. In spite of the fact that Ripple and the cryptocurrency community have denied the charges that were disclosed by the SEC, the persistent pressure from the government illustrates how awful things are likely to grow for Ripple in the days that are to come. According to Rispoli, the outcome of this litigation will have a financial impact on Ripple and will determine whether or not the company's operations tied to on-demand liquidity should be regarded legitimate. Ripple's financial condition will be damaged as a result of this action. As an additional point of interest, Rispoli is of the opinion that this action will unquestionably have an effect on Ripple's ability to carry out business activities. As a result of the fact that Ripple's holdings in XRP were substantially more than what was anticipated, the stakes in this legal battle are significantly higher than what was anticipated. Shield, on the other hand, is not the same as the Securities and Exchange Commission. If they are successful in the legal battle that they are currently engaged in, there is a larger probability that XRP and the alternative cryptocurrencies will reach $5. This is because of increased competition. A significant number of people were under the assumption that the price of XRP will eventually become closer to $5. This was due to the fact that XRP emerged triumphant in a judicial battle that took place the year before. This article is being produced at a time when the price of the token is $0.63, and it has been at the same level of strength ever since the completion of its case for the month of July in the year 2023. Since that time, there has been no change in the monetary value of the token. In addition, XRP will make use of positive dynamics in order to propel its price to substantially higher heights than it is today at any point in time. Every single one of the specialists is in agreement that it will soon be worth $1. The experts have reached a unanimous agreement on this point. Although it is anticipated that the bull run will begin within the next few months, there is a possibility that it might even hit $5 during that time period. There exists a possibility that this will take place. It is recommended that cryptocurrency investors get their hands on this cryptocurrency, which is regarded as one of the most significant alternative cryptocurrencies, if they want to make a sizable amount of money over the course of the years 2024 and beyond. The reason for this is the explanation that was provided previously in the sentence. However, there are some